Welcome everybody, good evening, good morning, good afternoon, wherever in the world you are joining us from. My name of course is Dr. Emily Jones and I am a senior lecturer at Essex Law School. And I am of course the co-founder and co-convener along with my colleague who you see on the screen, Dr. Megan Wong, of the Public International Law Lecture Series. And we're really excited to be back again this year. So for those of you who are joining us for the first time, welcome. Those of you joining us again, welcome back to the series. And it's my pleasure to be your host for today's opening lecture for the academic year by Professor Marcelo Kohen, who of course you also see on your screen, hopefully. It's an honor to start this new academic year with such an impressive speaker and such an important topic in international law. So thank you, Professor, for joining us. I will hand over to Dr. Wong shortly to fully introduce our speaker, who is obviously very esteemed, so there's quite a biography to go through. But before I do so, I just wanted to say a few words about the series. So now this is the third year that we're running the series, which obviously we co-founded together, myself and Dr. Wong. And the series was actually inaugurated by Professor Niels Blocker, who I think might be in the audience right now. So hi Niels, if you are, which was on the occasion of the 75th anniversary of the UN Security Council's first resolution. So Dr. Wong and I are both generalist international lawyers, but we kind of thought that this would be a good opportunity to bridge the differences between us because Dr. Wong is a formalist and I myself am a critical international legal scholar. So this series is built upon our deep respect for one another's scholarship, but also importantly, our friendship. And the series therefore prides itself on bringing two important intellectual traditions in international law, formalism and legal practice and critical legal theory together. And it's been a pleasure working with Dr. Wong, of course, on the series. Our speakers for this academic year include, of course, today, Professor Kohen, and then will be followed by Dr. Robert Knox, who is Monday next week. We then have Professor Ursula Kriebbaum, then Dr. Mamadou Ebi, Professor Douglas Guilfoyle, Dr. Julia Dem, and then for our closing event for the academic term, we're very, very proud to have two speakers with us and two ILC members, Professor Patricia Galvo-Tellez and Professor Martins Paparinskis. So now to introduce you to our fantastic chair for this evening or day, depending on where you are, Dr. Megan Wong. So Dr. Megan Wong is, of course, my friend and colleague and is a lecturer at Essex Law School and the founding director of the LLM in International Law degree at our school. She is a generalist public international lawyer and holds a PhD in public international law from Leiden University. She's the author of a forthcoming monograph, which is coming out with Cambridge University Press, entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. She's published on multiple canonical topics of general public international law and on specialist subfields of international law in peer-reviewed journals such as the International Comparative Law Quarterly, the Max Planck Yearbook of United Nations Law, and the Chinese Journal of International Law. And she is also a co-author of a Cases and Materials in International Environmental Law book that very recently came out. Dr. Wong has, of course, also additionally advised states on a variety of issues in international law. So that's our chair for this evening, obviously a lot of experience, and Dr. Wong, whenever you're ready, the floor is yours. Thank you.
Thank you, Dr. Jones, my formidable co-founder, co-convener of the Public International Law Lecture Series. I would like to echo Dr. Jones in welcoming everyone to our event today, also to welcome everyone to the new academic year. The beginning of the new academic year is always so exciting, and our opening lecture today is also so exciting. I'm very excited. Indeed, it is an honor for me to chair this opening lecture for the academic year, International Adjudication in Times of Crisis, by our very impressive speaker, Professor Marcelo Kohen, who is joining us all the way from New York City. So hello, New York. Before I introduce our opening speaker, I would like to go through some housekeeping rules. Professor Kohen will speak for about 40 minutes, and then this will be followed by a Q&A. Please feel free to type your question in the Q&A box. I will read out your name and affiliations unless you opt to be anonymous. And now it is with profound pleasure that I introduce our speaker, Professor Marcelo Kohen. Professor Marcelo Kohen is Emeritus Professor of International Law at the Graduate Institute of International and Development Studies in Geneva. He is a titular member of the Institut de Droit International and was first elected in 2015 and re-elected last year as its Secretary General. As one of the leading lights in public international law, Professor Kohen has played a significant role in the Latin American international law community and has been a continued source of inspiration to many international lawyers around the globe. Notably, he was one of the founders of the Latin American Society of International Law and its first Director General. Professor Kohen is candidate to the International Court of Justice for the 4th November 2022 election. In his extensive practice, he has acted as advocate and counsel before the International Court of Justice and the International Tribunal for the Law of the Sea for various states of Latin America, Asia, and Europe, as well as arbitrator in a considerable number of international investment tribunals. He has been the rapporteur of the Council of Europe, the International Law Association, the Institut de Droit International on matters of succession or jurisdictional immunity of states. And of course, when one comes to Professor Kohen's leading scholarship with a publication track record too lengthy and too illustrious to name, I shall point out that he has written extensively in French, English, and Spanish across a broad range of international law, thereby reaching out to a wide audience all across the globe. And last but not least, Professor Kohen is a much beloved mentor, role model, and teacher to a great many number of international lawyers who today are scholars, practitioners, legal advisors, civil and international civil servants. And it is great to see so many of you in the virtual audience, and of course, Dr. Mamadou Ebi, who will be speaking in our series this term. So really, what a wonderful speaker we have today to open our lecture series for us. And now I defer to Professor Kohen to give his lecture.
Well, thank you very much for this kind introduction. It's a great pleasure and honor to open this very stimulating international law series. I decided to address a topic which relates adjudication with the current international crisis. It is quite obvious, it is banal to say that we are living one of the deepest crises in international relations since the creation of the United Nations in 1945. This is a political crisis, it's an economical crisis, an environmental crisis, health, just to mention the most important elements of this different kind of crisis, but even though they are linked together to some extent. I mentioned a political crisis, and this relates in particular to the problems of peace and war, to the problem of the functioning of the collective security system. It's an economic crisis because inequalities are deepening, scarcity, even institutionally with the functioning of the WTO. This is also an environmental crisis with, in particular, the problems related to climate change and its consequences. And I need not to refer to health, since all of us, we have experienced what happened some time ago, even today. So we live in a world of crisis, and in these times, it is, I would say, even normal to questioning about the relevance of international law, the relevance of international institutions, which include adjudicative institutions such as the ICJ, ITLOS, arbitral tribunals, etc. For those of us who have reached a certain age, I can refer to the hopes that we all experienced at the end of the Cold War. So we believe that the time has come to a new order based in international law, and that was what was mentioned by most of the leaders of different states at that time. But instead, we experienced what I would call in one of my articles in the 1990s, a new international legal disorder: unilateral uses of force, collective security system block on key issues, the expansion of terrorism, grave and massive breaches of human rights, promotion of secessions in different parts of the world, and so on and so forth. Now, what we are living today, one could even say it is even worse than during the times of the Cold War, because indeed we are assisting to a kind of regression to the times prior to the Briand-Kellogg Pact. That is to say, we are assisting today at the use of war as instrument of national policy, something that was precisely prohibited by the Briand-Kellogg Pact. What are the consequences of this crisis? Well, one is the weakening of the collective security system. My first question would be, is there a crisis of international law too? My first attempt to react to my own question would be, no, there is no weakening of international law. What is weakened is the system of international security, the collective security system of the United Nations, the manner in which one can judge international law does not depend on the breaches and the consequences or lack of consequences of the breaches. We can hear here and there, well, this is the evidence that international law is not law, or it's a pure illusion, or it's a mere theory of international relations and nothing else. And I have to say that even within our community, some discourse of the law is indeed assist those criticizing international law or even denying its existence. Of course, there are different manners to interpret the law, and this is something which is common to all legal systems, not only for the international legal systems. If the whole community to which the law is addressed had exactly the same interpretation, and if all participants in the societies concerned would respect this very same interpretation, there would be no conflict and there would be no need for law. Law, by definition, implies the recognition of the existence of conflict in any kind of society. And this is also true in the field of international law. Is it the fault to international law, the current crisis? Because this is also something that we can hear. I'm at some matters of the headquarters of the United Nations when I'm speaking to you, and this is something that one can hear in the premises of even in the premises of the UN headquarters. What I would say is the following: international law is not an entity. International law is not an organ. International law is not a state. It's not an individual. It is simply the international legal system that the international society has painstakingly forged after the major catastrophe of humankind, which was the Second World War. So to say that it is the fault to international law, or it is shameful that international law has not envisaged this or that, is really to put the accusation to the bad target, because international law is what the actors of the international society are willing to have as legal system. So if there is any responsibility in the current crisis, and I put crisis in plural, I would say, it is not to be searched in international law. I mentioned one of the main problems that we are facing today, which is the question of peace and war. And it is not just the specific situation in Eastern Europe, but it is the situation which concerns all of us. Because when we hear voices about the possibility of a nuclear confrontation, we see that the situation is really grave. And the question of, it is not just the question of the use of force, but it is the question of the use of nuclear weapons. And I have to say that after the end of the Cold War, we hear some voices praising the use of force as a means to solve problems. I wrote at that time that war is never the best appropriate tool to make advance just causes such as human rights, democracy, etc. I have just to remember, I will just mention two authors. Michael Glennon, at the beginning of the 21st century, he wrote, well, Article 2, Paragraph 4 doesn't exist anymore. Or Edward Luttwak, he published an article in Foreign Affairs in 1999, whose title was "Give War a Chance." And I told my students, I prefer John Lennon instead of Edward Luttwak. So, and now we see where these kind of considerations weakening the scope of the provision of the use of force have led. I'm aware that there can be a sensation of frustration, because in highly political sensitive issues, decisions that have been taken by adjudicative bodies have not been fulfilled. So this puts a problem with regard to compliance with international law. And this is also something which is very important to distinguish. International law in itself is one thing. Compliance with international law is just a different thing, although obviously closely related. I mentioned that in some cases there had been decisions of the ICJ, for instance, just to mention the ICJ, which were not followed by implementation. Yeah, I can mention for instance, just the last order of the ICJ in the allegations of violations of the Genocide Convention case, Ukraine versus Russia, the order of the court indicating provisional measures. I can also mention advisory opinions. The advisory opinion on the construction of a wall on occupied Palestinian territory and the separation of the Chagos archipelago from Mauritius in 1965. These two advisory opinions have not been followed by the implementation of the consequences mentioned by the ICJ as the legal consequences. We all know that advisory opinions are not binding per se, but the court, what it does in advisory proceeding is to ascertain the status of the law. And we can see that these situations in which we see that there is no compliance is something that may cause frustration. Yeah. Does it mean that we can lose faith in international adjudications? I don't believe this is the case. We can also mention some other problems within international adjudication, because since I mentioned advisory opinions, and I mentioned two advisory opinions that were not followed by the consequences, I can also mention other advisory opinions in which indeed the ICJ didn't answer the questions raised before it, such as the legality of the threat or use of nuclear weapons or the unilateral declaration of independence in respect to Kosovo. We also see cases of non-appearance before courts and tribunals. Sometimes one could say it could be justified, sometimes one could say it should not be justified. The fact is that the statute of article of the ICJ, Article 53, if my memory is right, envisages this possibility, which is indeed, I don't believe it is a right, but it is just a factual possibility. But it is quite clear that lack of appearance doesn't assist the court in its functioning. Yeah? We also see a kind of political attacks in different states with regard to regional courts of human rights. They are criticized because they consider that these regional courts of human rights are going too far, disregarding the sovereignty of states, etc., etc. Well, these are the arguments that were advanced at the time of the creation of these very institutions. And this is the permanent struggle between the consideration of what is part of the questions that pertain to the exclusive domain reservé of states and what are issues of international concern. And it is quite clear at this stage of the 21st century that human rights rules of international law are matters of international concern. So we have this picture, which is not very satisfactory to say the least. We can also imagine that the old dream of compulsory jurisdiction, compulsory courts to deal with all disputes that may appear in different aspects of international relations. This old dream remains a dream, and probably, certainly, I believe all of us, we will not see it. But the idea was precisely that through adjudication, peaceful settlement of international dispute can be advanced, and this could be an appropriate means to settle international dispute that otherwise would be impossible to settle because the position of the parties are very different and opposite. So the question I would like to mention here is, well, how the International Court of Justice in particular, because we don't have time to address all international courts and tribunals, but how the court should act in times of crisis, like the one we are facing today. I always remember the fact that the ICJ is not just a mere court, and it is not the court having general jurisdiction, because every dispute concerning international law can be submitted to the International Court. It is the only court at the world level having complete jurisdiction in all matters of international law. But something which is very important, the ICJ is an organ of the United Nations. And as the Charter said, it is the principal judicial organ of the United Nations. And as such, the court has a specific responsibility. Obviously, we know that the court cannot act on its own initiative. The court can only act if states allow the court to act, or if the relevant organs duly authorized may request an advisory opinion. Otherwise, the court on its own cannot address crucial issues of international law that may be discussed at the international level, but the court cannot on its own address if there is no state will, and I say so both in contentious procedures and also in advisory procedures. In other words, the court can only act when it has jurisdiction, and jurisdiction can only be given to the court with the consent of states or with the decision of a relevant organ, which requires the vote of states in order to request an advisory opinion of the ICJ. I mentioned this idea that the court is an organ of the United Nations, and as such, it has to participate in the activity of the United Nations for the maintenance of peace and security, which is one of the fundamental roles of the organization. And I would like to quote two different orders of the ICJ that were adopted in two different circumstances. I will put them on screen. I think you have on the screen, yes. Two orders of the court on request for provisional measures. The first one I would like to mention is the one adopted by the court in 1999. Indeed, there were many cases concerning the legality of the use of force. It was the then Federal Republic of Yugoslavia versus those states, members of NATO, having used force during the Kosovo crisis. So it was the Federal Republic of Yugoslavia that requested provisional measures, and the court rejected this request. The court didn't indicate provisional measures, but there were some paragraphs of the order that were very, very important, in which the court recalled its function. Allow me to briefly refer to it, and then I will mention the most recent order also with regard to same questions concerning the use of force. So the court said in 1999, the court is deeply concerned with the human tragedy, the loss of life, and the enormous suffering in Kosovo, which form the background of the present dispute, and with the continuing loss of life and human suffering in all parts of Yugoslavia. The court is profoundly concerned with the use of force in Yugoslavia. Under the present circumstances, such use raises very serious issues of international law. The court is mindful of the purposes and principles of the United Nations Charter and of its own responsibilities in the maintenance of peace and security under the Charter and the Statute of the Court. The court deems it necessary to emphasize that all parties appearing before it must act in conformity with their obligations under the United Nations Charter and other rules of international law, including humanitarian law. This is very important for the following reason. The court in these cases didn't indicate provisional measures because the court considered that prima facie it appears that it didn't have jurisdiction. In other words, even if the court considered that it didn't have jurisdiction prima facie, and then it was confirmed later on, the court felt the need to indicate these basic propositions. The fact of the tragedy, the human tragedy, the fact of the use of force, the fact that the principles and purposes of the Charter must be taken into account, and this is a responsibility for all states. That is to say, even without jurisdiction or without considering that prima facie it had jurisdiction, the court indicates this. And then, very recently, the court did exactly the same in the provisional measures indicated in its order of 16 March 2022. So the court practically repeated word by word what it had said in 1999. The court is profoundly concerned about the use of force by the Russian Federation in Ukraine, which raises very serious issues of international law. The court is mindful of the purposes and principles of the United Nations Charter and of its own responsibilities in the maintenance of international peace and security, as well as in the peaceful settlement of disputes under the Charter and the Statute of the Court. It deems it necessary to emphasize that all states must act in conformity with their obligations under the United Nations Charter and other rules of international law, including international humanitarian law. So, this is just to show you that the court is perfectly aware that in times of crisis, no matter whether it has jurisdiction or not, no matter whether it has already determined that it has jurisdiction, the court is able to go ahead and indicates its role as an organ of the United Nations and its possibility to act even in these circumstances. Obviously, this is what the court has said in these two orders indicating or not provisional measures, but we know that the court can only act, as I said, if it has jurisdiction. And the question is, if it doesn't have jurisdiction, obviously, unfortunately, we could even say, but the court cannot address all the problems of the world. The court cannot decide all the disputes, and the court cannot take stance about all the great breaches of international law that occur. But the question is, when the court does have jurisdiction, the court must exercise it in all its extent and without any kind of attention to political pressure. The function of the court, the function of any judge, is to act exclusively in the application and interpretation of the rules of international law without paying attention who the actors are, who the parties are. No matter who is the author of the breach or who is the victim of the breach, the court has to act applying the rules in an equal manner if the situations are exactly the same. This is a very important point because in advisory proceedings, sometimes we could see states coming to the court saying, well, the question is politically very sensitive, the court should abstain. But the court is not there to address political sensitivities. The court is there to address legal issues. And it is the contribution of the court, because how can the court contribute in times of international crisis? Just with the ascertainment of the law, nothing else. The court is not there to take political decisions such as the ones that the Security Council or even the General Assembly can adopt. The court is there just to state the law. And this is what one can expect from the ICJ. But I said, and you know that I am Argentinian, and I would use a common phrase that it is used in English, you need two to tango. And it is indeed the case. And as I mentioned, the court can only act if the states go to the court. And here, what I can say is, in times of crisis, it is particularly important that states use all the available judicial tools. I don't believe that one can criticize a state for having recourse to the all available tools that they have at their disposal. And this is true in contentious cases, and this is also true in advisory proceedings. I'm not saying that one can abuse of the exercise of advisory jurisdiction, but we know that the court had clearly mentioned when the argument that this is a bilateral dispute and the court should not pronounce, that the court clearly mentioned that when matters are of international concern, when matters are within the realm of the competencies of the organ having requested the advisory opinion, the court does have jurisdiction, and there is no reason of propriety to prevent to exercise its jurisdiction. Yeah. So in this regard, we all know that today many states are using of the possibilities given by the Statute of the ICJ, Article 63 of the Statute of the ICJ with regard to the construction of multilateral treaties. If a multilateral treaty is the object of a dispute between two states, all parties to the multilateral treaty have the possibility to appear before the court and to request to intervene on the basis of Article 63, and the construction of the court of the multilateral treaty will be binding to those states. There is also the possibility of Article 62, which is intervention with the legal interest of third states are at stake. And with regard to advisory opinions, I would say that this is a field in which the court can make major contributions to the general understanding of the existence and interpretation of international law rules. And the question is not whether the matter is controversial or sensitive. The question is whether the answer of the question can be fully addressed by the court, can be, if the court can explain the content of rules, or can determine the existence or not of given rules, or can apply the international legal system as a whole with regard to a very particular problem. Yes, this is something which is important. Just to mention other adjudicative bodies or systems. I mentioned just one case, one advisory, the last advisory opinion of the court on the separation of the Chagos archipelago. I mentioned that even though the court considered that the United Kingdom should withdraw from the Chagos archipelago and it didn't happen, it doesn't mean that there are no consequences. And here I would like to give the example of ITLOS and the decision of the Chamber of ITLOS, giving effect to the ascertainment made by the ICJ opinion in the Chagos archipelago for the determination of the maritime delimitation between Mauritius and Maldives. So this is a clear example that even though advisory opinions are not binding, they can have a particular legal effect because of the importance of the findings of the ICJ on legal issues. Most probably, if the question would have not arrived to the ICJ, or if the ICJ would have not given its advisory opinion, ITLOS would have not had this possibility. Just a few words to start to conclude. Indeed, with regard to investor-state dispute settlement system, we know that this system has been the object of many criticism. We know that there are current efforts through UNCITRAL, through unofficial bodies, to improve the ISDS system. One of the criticism is the so-called structural bias that this system is accused of. There are current ideas about the creation of a permanent court that may solve some of the problems, in my view. We know that if there are contradictory case law in this field, it is because of the composition of arbitral tribunals. At the end of the day, when you have hundreds of arbitral tribunals composed in a different manner, not to have contradictory decisions would be rather a surprise. And this is a serious problem because of the uncertainty that this creates. We also know that many consider that this system is unbalanced, that too much attention is paid to the right of investors and less attention is paid to the needs, the social needs of states. I will not enter this discussion about the manner to improve the system. Maybe the creation of a permanent court may solve some problems with regard to the fact of not having all these different arbitral tribunals, some problems concerning the delay in rendering decisions by arbitral tribunals, the problem of lack of contradictory case law. But even with a permanent court, many problems may remain open. I would like just to refer to one question, which is the original purpose of the system, which is often neglected. The original purpose when this system was created in the 1960s was to promote development through foreign investment. A question that I leave open, but this is probably for other sessions of these lectures. Is this goal of the system, is it really taken into consideration today? I have some doubts about that. When we see the different kind of cases that are brought before international arbitral tribunals, and we saw also some decisions in this regard. My question is if one adopts a very extreme position, because the idea at that time was promotion of development through foreign investment in order to give foreign investors some insurances, because there were doubts about the capacity of domestic courts and tribunals to really address disputes between foreign investors and the states concerned. And that was the reason of the creation of this possibility to refer to international arbitration. My question is whether it wouldn't be worth to put emphasis in the promotion of the real independence of the national judiciary systems, and leave, since we are talking about investment, etc., leave, I would say, for the market, so to speak, the choice in which states, in which foreign investor, in which states a foreign investor could act with confidence in the domestic legal system and in domestic judicial. So I think I would like to start my conclusions, and I would say we have the essential role of the International Court of Justice today. We see that the International Court of Justice is seized with very, very crucial, important cases. Some cases concerning the Genocide Convention. We see that in some cases we have states actively participating in these procedures. But to my astonishment, I would say that similar disputes, which are even before the court, apparently do not deserve the same treatment, something that it's can be unexpected, I would say. But I would like to recall what Judge Manfred Lux said with regard to the court. The court is not only the general guardian of legality within the United Nations system. In fact, the court is the guardian of legality for the international community as a whole, both within and without and beyond the United Nations. So the court must play this role when it is possible for it to do it on the basis of all my prior considerations concerning jurisdiction and the attitude of states. I believe that in time of crisis, it is worth reaffirming the need for the rule of law in international relations. Obviously, international law cannot create in itself the best of the worlds. The worlds are what the actors decide to do. But the respect for international law, the respect of international law is an essential condition for achieving a better world. International adjudicative bodies, we all know, cannot impose compliance with their decisions at the international level, but as the guardians of international legality, they can state what the legal situation is, and this, sooner or later, has a positive impact in international relations. Thank you very much.